No, get out of here. Get Thank you. Welcome everyone, not you guys. um Welcome guys. It's good to see you. I hope everybody's doing well today. Um yeah, this I expect this to be an intimate gathering here for this. Um and I mean, yeah. What are you gonna do? There's it's I guess it's still a hot topic, when somebody said something about somebody riding a dick and having a whiny voice, and I mean it's riveting. Anyway, um, so what we're gonna do tonight, we're not going to go into a deep dive on this case yet. You guys know, guys have been with me for a while, and how I like to handle cases. I don't necessarily. I mean, I'm like I like true crime, and I kind of mess with it, but I don't really consider myself a true crime channel because there's so many other channels that do true crime so well. And I was actually warned yesterday that this was the kind of case that you really have to like really dig deep and 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 get a lot of information, and there seems to be a lot to it. I started kind of messing with it, and then I was like, you know what? I like to do these. I like to have reactions. Um, so I like to go over this stuff with my chat, and this basically what all we're going to do is we're going to go over yeah, we're going to go over today's well, not today's, but the most recent court hearing. um but there is a case here. Sorry about that, technical difficulties. um oh, and I lost my chat through StreamYard. um there is a case here. We'll go over. I'll just give you guys a little rundown. um so I believe it was January 2021. It's a really simple story initially. When you think about it, basically you have Karen Reed, who was driving and was apparently bar hopping with her boyfriend, who's a 16-year police veteran for, I think, the Massachusetts State Police. I'm not sure if it was the Boston PD or the Massachusetts State Police, or the Staties, as they like to call themselves. Um, but Apparently, after drinking, they went to a fellow neighbor's house. I believe his last name is Albert. A fellow police officer's house. I believe his last name is Albert. His first name is slipping me right now, but he apparently. Oh, look, lawyer mystery Mavid's in the house. Hold on, let me give you back your wrench. I got rid of everybody's wrenches. There we go. Um, so basically, after drinking, she allegedly dropped him off and then backed her car, her SUV, over him, knocking him unconscious, and then leaving him on the front lawn to freeze to death. Uh, and so um, the problem with that is her defense has a much different story. And it seems uh, the more I'm looking into this, the more I'm thinking that it's strange how the prosecution doesn't seem to be presenting a case against her, which the burden of proof is on them to present this evidence, but yet they seem to actually be withholding evidence from the defense, or at least that's what the defense is accusing them of. And what they are alleging is that he entered the home, that John O'Keefe entered the home of a fellow police officer where other police officers were, and they believe that he got into a physical confrontation with someone there, and a dog, a German Shepherd, attacked him. Now, this is fascinating because the dog is nowhere to be found. We don't know where the dog is. And there's a lot of like I said, there's a lot of different evidence that they are that the defense is accusing them of Cordy, that's very big of you. Thank you so much. See, look at how that works, man. I made a new friend. Thanks, Cordy. I appreciate it. Yesterday when we were discussing this on a panel, Cordy was in there. She was like, "You suck at true crime," all in the chat. And then she was like, "Someone covered this case," when we were talking about it. And I was like, "You know what, Cordy? I'm going to do it just to piss you off." And so here we are. And now Cordy is showing her appreciation for it. So thank you. So anyway, now what they're saying is that the prosecution is just not giving them evidence. They're not sharing the evidence with them. So they haven't had a chance to go over all of the evidence that they're supposed to have in order to come up with a proper defense. And there's already been 2 hearings. And here I'm going to go ahead and play one, which is the most recent. Now, mind you, I'm going over this kind of out of order here, but we're just going to go over. I have the affidavit, but I'm not going to go over that because that's like 23 pages, and I'm not going to go over that tonight. As it says in the title, this is just an introduction. This is just to familiarize you guys with kind of more or less what's going on. There's a whole nother level to this that I'm going to explore, which is a dude named Turtle Boy. No, I'm not talking about Dolly. I'm talking about a dude named Turtle Boy. He's a YouTube creator, and he is deep in this. And I went down a little rabbit hole, not too far, but I went down a little rabbit hole. Is it 34 pages? Thank you, Cherry. I went down a little rabbit hole of his content, and I'm just like, this guy is wild, totally wild. So I'm going to go over, we're going to go over this most recent hearing. And hold on. All right. Now, I'm glad Lawyer Mystery Baben's in here, because what does that mean? Because it says that she's asking, this hearing is her asking for bail to be removed, for the bail to be dropped. Isn't that a bad thing, or am I misunderstanding that? Like, why would she not want bail? See if there's improvement on volume. Here we go. That's the best I can do on volume, guys.
Motions. So there have been, what I understand, what I have is 2 Rule 17 motions filed by the defense, one essentially for records when you can't tell where we got.
Oh, so they're essentially asking to just drop the case. right? So they're saying for the prosecution to just drop the case, for the judge to just drop the case and give her bail money back. Okay.
So whoever's on Zoom, you have to be.
I mean, they haven't presented a case yet, as I understand it. Ha, that's funny, Team Brittany. Oh, hold on.
And then there's a recent motion regarding exhaustive testing, then there's motion for me to review conditions of bail, and we're also going to set a scheduling because these piecemeal Rule 17 motions coming in with an affidavit with possession of counsel since January 2022. We're not going to keep doing that, we'll set firm dates. So before we start with motion to compel, have the third party record.
Yeah, I'll do that, Tigress. And there's some stuff now. Let me be clear about something here. There's some stuff that I did watch that I can't go over because I don't want to get dinged by Court TV. But my man Turtle Boy got interviewed by Court TV, as well as Karen Reed's attorneys, two of her attorneys. So and it was fascinating. Like it seems like they have an overwhelming case to disprove the prosecution's case. It's really bizarre that this is just going on. I'm not saying she's innocent. I'm saying there's a lot to make you think she is. There's definitely a lot to make you think she is.
So yes, with respect to each of the respective 5% teams on defense, I think I know it's called third-party subjects.
Did you get any responses from any?
So let me give a little recap here. For Sweet Crazy. So Sweet Crazy, there's this woman, Karen Reed, who is charged with second-degree murder for killing her police officer boyfriend. And she claims that she's innocent. And supposedly they were out drinking. Then they went to a fellow police officer's home. She's not a police officer, but a fellow police officer of John O'Keefe, her boyfriend. They go to his house, and what she's being accused of is he gets out of the car, and then she backs the SUV over him, knocking him unconscious and leaving him to freeze in the cold. But what her defense is saying is that's not what happened. What the defense is saying that what happened was she ended up, or John O'Keefe ended up going inside the home of the fellow officer, and there a fight ensued somehow, and he got beat up and attacked by his dog, and then left out in the cold. And as I understand it, the sister-in-law, I believe it's the sister-in-law. Guys, remember, I'm shaky on all the facts right now, but I promise I'm going to go over all of the facts and all of the details. This is, like I said, just an introduction to the case. Okay, Lawyer Mystery Maven's catching up. She says, oh, it's to dismiss the case. The only thing that comes to mind was remove bail conditions. That's what somebody else had just said. Awesome. Thank you, Lawyer Mystery Maven, for clearing that up. So that's my question to Lawyer Mystery Maven was that, you know, what is this hearing for? Because it says Karen Reed asks for bail to be removed. So okay, so Tigress believes that she's absolutely guilty, that she was drunk and there was a blizzard and they were arguing and she ran him over with the car. And there's no cover up. But there's a lot of evidence that dictates that, you know, there is. It certainly seems that way. I don't know. I haven't made up my mind. But what I'm saying is it just looks bad because the injuries that he sustained don't seem to be consistent with being road rash. And I think, as I was saying, I think it was the sister-in-law of the officer who owned the house that apparently Googled how long does it take for a body for a human being to freeze to death in the cold. Something to that effect. I don't have that verbatim, but something to that effect. So yeah, this stuff is pretty fascinating.
Does he work in Berlin? All right, so it makes sense then to stop with 17 motions. Nothing, where the record was given enough time.
As it pertains to the common law motions, yes, I did receive, this latest one, last.
The volume's crazy. All right, so listen, what I'm gonna do, I'm going to go to the other hearing that happened 4 months ago. I'm going to go over that.
Worksman Jackson and
This will give you a little bit more of an idea of what her case is versus what the prosecution's case is, at least.
Quinn, along with Elizabeth Little from Worksman Jackson and Quinn, on behalf of Karen Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Little. Good afternoon, Ms. Reed. Okay, so we're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are two motions before the court that we'd like to be heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases. And I would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court. We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in two prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life. And for the last 15 months, she has.
I appreciate that, Phil. Thank you so much, buddy. Means a lot.
Been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family.
That's what Chasing was saying yesterday. She was saying, like, look at the cops, like, standing there, like like, look at these guys looking like a gang of thugs. I mean, it seems unorthodox, but at the same time, it's Boston. You know what I mean?
Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from two coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at
Uh-oh. Phil lives in Boston. Phil lives in Boston. He's got a car. He's got a fucking second car.
stake. In the 11 months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it. We haven't inspected it. We haven't been able to test it.
And I don't want to talk too much shit about Boston. Actually, I really like Boston, and everybody that I've ever met from Boston, I really liked. This reminds me, like, if these cops are dirty, right? Like, it just reminds me. I just watched, like, literally, like, not even an hour ago, I just finished watching the finale of this show on HBO called Winning Time, which is about the Lakers rivalry with the Boston Celtics. And and there was like one game in the finals, 1984, where Larry Bird was just playing dirty. The refs were dirty, and man, yeah, it was just, at least that's what was implied in the show. Now, it was a dramatization. It wasn't like actual footage of the games, but it's a good show. I recommend it, even if you don't really enjoy basketball. Like, it's pretty fascinating. But it's just funny to me, like, today just seems to be this whole Boston's dirty. It's got this Boston's dirty vibe to it.
In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending. But 15 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again.
See, this is what's getting me. Okay, folks, like, this is what's getting me about this case. It's very strange to me because we've covered trials on this channel. We've talked about cases, and it's real simple. Normally, what do I always say on here? That a defense attorney's job is merely to create doubt. Like, normally they're going to be the ones that want the evidence suppressed. They want the evidence. They want the evidence shown. They feel that the evidence that's been collected in this case is absolutely going to exonerate their client, the defendant. So, I mean, yeah, Phil, it's still going. It's just, it hasn't, like, the trial hasn't started. The trial's not set till March of next year. But I find it, this is what I find very strange, is normally we see defense attorneys trying to deflect evidence or discredit the evidence in some way. But what we're seeing here is they're demanding more evidence. Now, obviously, okay, me wording that is bad. Of course, they're going to demand more evidence from the prosecution in order to, like, hey, well, you're not proving anything. So, but they're saying that the prosecution is in possession of evidence that they feel can exonerate their client. And it feels like there's more than one piece of evidence that they feel that can do this that they don't have access to, which is very strange. Hold on, let me get Burden. What's up, Burden? They feel that they feel that there's just multiple pieces of evidence that they feel can exonerate their client. Whereas normally all they're going to do, their best defense is just to create doubt in just one juror. But that's not happening here. The prosecution seems to not be wanting to put forward a case or to be reluctant in putting forward their case. And the defense is enthusiastic about the prosecution putting forward this case and presenting the evidence. Like it's so weird. And remember, I am like here's a layman and then there's me. Okay. So I just want to be very clear about this. I barely understand how the law works. I just know just the overall basic concept of due process, more or less, and probably leaning closer to less. So just understand this. I'm just a guy who finds this stuff interesting, but I am not very well educated, so I do apologize.
The response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's...
And that's another thing, man. Like, it's usually the prosecution that's stalling for time, not the defense. The defense is usually stalling for time. Sorry, yeah, I said that wrong. It's usually the defense that stalls for time. It's usually the prosecution that wants to get things going. They want to get that conviction. But the defense seems to be stalling for time. Or God, sorry, I'm confused by somebody's getting timed out in the chat, and I'm just okay. Yeah, rapper, you can go away. Sorry, I got confused. Let me rephrase all of that. It's usually the defense that stalls for time, not the prosecution. And it seems like the prosecution is stalling for time, which is totally unusual. It's totally unusual. Or at least it seems that way to me, based on other cases that we followed. I mean, look at Letitia Stout. With the Letitia Stout case, she did everything that she could to stall and to avoid the inevitable. These people are like, her defense is costing money. She's lost her job. She's lost her reputation. We want to get her life back. This is how confident they are in her innocence. Like, this is really weird to me, man. Really weird.
Savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m.
Yeah, Kendra, that's what I thought too. But apparently, that's what this attorney is asking for. If I'm understanding it correctly, he's asking the judge for a deadline for them to share the evidence that they have. I mean, lawyer mystery maven, I'm wondering, the question I have for you isn't the prosecution required by law to share what evidence they're going to use? Like, isn't it called like putting it into discovery? Isn't that what that's called? Whatever they're planning on using to prosecute and prove their case, they are required to share it with the defense. Yes or no? And apparently they're not doing this. And the defense is getting anxious because they're saying her savings are being drained and her life is slipping away and she's innocent.
On January 29th, because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage floor. 1 Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m.
No, she wants the speedy trial. That's the whole thing. That's why this is so back-asswards. She wants the speedy trial. Hen, this is just fucking weird. It's just bizarre. And they're like, I mean, she has the right to it, but normally the defense is usually stalling, especially if there's guilt and it's difficult to prove. Or it's not difficult to prove, sorry.
a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle.
Okay. He wants to get firm dates. They may or may not have agreed on postponing deadlines at prior times. Have to check docs. The DA has to provide evidence in discovery. Exculpatory? What does that mean, exculpatory? Including exculpatory. I'm shaky on what that word means. Sorry. But I watched this yesterday, and I watched this yesterday, and if I remember correctly, the prosecution is denying that, or at least claiming that there were there was talk of postponing deadlines. I think he's claiming that they did discuss that, or at one point says that he tried to contact them and he couldn't get a hold of them, or something to that effect. But I'm not 100% sure. I only watched this once, and I watched it yesterday, so I don't really remember.
Her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file. I'm sorry, the Canton Library provided this evidence to them via a share file link with the guest ID.
Okay, so exculpatory means that tends to show that the defendant did not commit the crime. Okay, so but yeah, you said that they have to include that, and they haven't. So this is, I mean, this is what they're arguing, that it's a violation of her rights. It's a violation of her rights to due process and a speedy trial. Huh.
And a guest password, we need that link, that user ID and that password. We cannot rely on Trooper Michael Proctor, conflicted Michael Proctor, to sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold while she spends every waking moment defending herself emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence. Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor.
Yeah, sorry if this gets on people's nerves, but I am, it's a lot easier for me to understand this case when I have an actual criminal attorney in the chat. So when she says things, I'm going to highlight them and I'm going to read them because it not only helps me understand better, but it's going to help you understand better, those of you who are not attorneys, even if she says something you already know. But just know, I don't know yet. So I'm going to stop and highlight her comments. Lawyer Mystery Maven says, I don't know the specific evidence this attorney is referring to as exculpatory. It's possible DA doesn't believe it is classified that way. Hence this motion argument. Okay. But I mean, if it's either one, they're still obligated to provide it, right?
In response to counsel's motion, just in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with her innocence.
Okay, so this is the prosecutor here. Now, for those of you who are wondering, like, and in response to what you were saying, Jess, in response to what you were saying, you're going to hear some of that stuff from the other defense attorney. There's 3 defense attorneys that seem to be up there, 3, maybe 4, but or 2 main counselors and then 1 or 2 or their co-counsels, maybe. I don't know how that works. But there's 4 people up there. And I know that 3 of them are her attorneys. And the other male who speaks next after this prosecutor he's done, you know, sorry. Once he's done countering what was just said, he'll speak up and he's going to explain a little more about the case and show some examples. It's pretty eye-opening, pretty crazy stuff.
I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when as related to inspection of said materials, the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis that could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th. Those items, at least as far as the trace analysis and the criminalistics was concerned, would be completed, and I should expect something close to that date. I confirmed with the lab as of yesterday that that timeline is still a viable one. The case is currently in technical review, so once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the
Okay, but all right. So that's fascinating right there. So lawyer mystery maven saying usually a DA leans towards being conservative with that evidence in discovery. There could be a ton of items collected as evidence, but not actually submitted. May have been collected by Ali, but DA won't use. Okay, but doesn't she have the right to that evidence in order to? I mean, if the system is designed that you're innocent until proven guilty, why wouldn't her attorneys be entitled? And I want to emphasize on that word. Why wouldn't her attorneys, her defense, be entitled to that evidence in order to prove her innocence if they think it can? I mean, whether it has to be provided by the DA or whether it has to be provided by law enforcement. Right. No, I know what you mean. Specifically, you're not saying necessarily holding back the evidence, but keeping it there just in case, more or less, and not necessarily what they're going to use. Dude, I'm so glad you showed up in my chat for this, because this shit is very confusing to me.
to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the district attorney's office for the state police's custody. One of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA for comparative purposes to Mr. O'Keefe would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails. I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is
I saw that,
why
Kendra.
at least in no small part, why some of the items are still contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that.
Bro, who told this guy? Like, I always get fascinated with dudes. What is this like? Is this the equivalent to a comb over these days? Is to just like you're losing all your hair, and then you just like do what you can with the gel with to try to not appear like you're losing all your hair. Like, dude, just shave your head, bro. Just shave your head. Like, if I'm a judge or a juror, I'm going to respect you a lot more. I'm going to be like, dude, what does this tell me about him? You know? Like, he looks like he hangs out in bathhouses. You know what I mean?
By next week at the latest. And again, whatever deadlines that the court sees fit to or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to Rule 17. So there's been some photograph taken from a social media site, which is purported to be Trooper Proctor with one of the McCabe's children who were a witness in the case. The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative.
Oh yeah, yeah. Quick update. My coffee pot, I fixed it. Yes. I fixed it. So I didn't have to buy a new one. But I appreciate all the concern. So Stacey O, evidence used in a grand jury is not subject to the same rules as trial. It's much more lax, with evidence to be used in trial subject to high scrutiny. Okay, see, this is good stuff because I just, like, as you can see, I watch a lot of SVU, and that's mostly the extent of my knowledge of the law, which is not a lot.
Relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it, essentially it won't open. So the link expired within 30 days, within 60 days, if not 30 days of it being shared with our office. But the exact information that was
Y'all see that validation highlighted right there, bro, from an actual lawyer? Huh? See that validation? I'm a big fan of it. Hold on. I got to make it official. Hold on. Ready? I got to make it official. One more time. There we go. Okay.
was provided by the town of Canton, was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archived within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
Okay. All right, your next motion?
That would be Mr. Jackson.
Okay.
So, just so you know, that dude spoke really fast, and I understood about like 5% of that shit.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue. That Rule 17 motion, we're seeking summonses directed at 2 entities. The Canton Animal Control.
Now, real quick, you see this guy with, see if you can see my cursor. You see this guy right here with the short blonde hair and the green shirt, black jacket, black tie. That dude is a YouTube creator called Turtle Boy. And we're gonna go over some of his stuff because that shit is fun. That's a whole nother monster in this case here, folks. That's yeah. I'm gonna try to get a hold of him and see if I can get him up here once I familiarize myself with the case a little bit.
Control and the Canton Town.
And then I mean we'll see, because you know He's a busy guy, but we'll see.
Both. We believe they both have records. We know they both have records. These are records that we need, the defense needs to shine a light on Karen Reed's innocence. These are records that are essential to our theory of the case. And these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number one, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact. Where he was.
Okay, now you got to take this with a grain of salt, but if you listen to these details that he's putting out there, he's going to give you guys who are just joining us a basic summary of the case. But keep in mind, it's the defense's summary of the case. Okay. So it's, it's one-sided, but there are certain facts that he is, so this is a good opportunity to kind of familiarize yourself with why we're here.
He was found dead and what the circumstances were surrounding that death are why we're here now. Second,
I'm going to play that one more time.
On January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact. Where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact. When John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case.
Listen, y'all, I'm no expert. I'm not a medical examiner. I'm not a coroner. I'm not a doctor. I'm not a nurse. None of these things. Okay. No training in the medical field whatsoever. But I've seen road rash before. Okay. I've seen road rash before. That shit don't look like road rash. It could be road rash I've never seen before. But yeah, I've seen dog scratches and bites. Yeah. Looks more like that. But yeah.
One way or the other, this is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal? Which is exactly what they are. Second,
one could argue, and this is a little controversial, folks, because I know that a lot of people are very familiar with this case and your minds are pretty much set. But one maybe could argue, I don't know, but possibly could argue that those are defensive wounds we've seen wounds like that on somebody who killed somebody in a struggle, right? But he's the victim. So, but one could argue, but the thing is now let's go back real quick. Let's explore that for a second. Let's get a closer look at those scratch marks. The only way that those would look like it, because in the direction that they're going, the only way those could be defensive wounds from him attacking someone else. Okay. Which the scenario is not even out there. Just for the record, the scenario is not even out there that they got in a physical altercation and then she ran him over with the car. So that scenario is not even on the table. But if that were the case, right? If say he was strangling someone and that person was scratching to get them to let go, they would be vertical. You know what I'm saying? They would the scratch wounds would be vertical, not horizontal down his arm. More than likely. It seems that way to me. But he explains pretty much. Now I could see it happening if maybe he had someone in a chokehold. He was behind someone and had them in a chokehold, and then that person started scratching to get them to let go. But like I said, that scenario is not even on the table. They're saying it's road rash. And they're saying that he had a cocktail glass that broke, and the cocktail glass, I mean, so it's either a cocktail glass that broke that he scraped over on the ground, or it's road rash. Those two are two very different things. So this is, yeah. I feel like the prosecution's, as far as this goes, the prosecution's case is very weak.
Following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash.
See, that's a fun lawyer trick right there, what he's doing, because he's planting seeds. He's just saying, does it look more like claw marks or bite marks from an animal? So it doesn't seem like, I mean, to me, it just looks more like claw marks and maybe bite marks, but claw marks specifically was what they look most like to me. But to throw that in there and say, oh, from an animal, he's already, I mean, he's really paving the way to keep to get this judge to start thinking on his level.
Where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled in gravel because of the car, what about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from.
Look at, I can't help but look at these cops back here, man. Like, these cops back here are all business, and they look more and more annoyed the more that this guy talks, which I find pretty fascinating. You know, I like to kind of read the room in situations like this.
From a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth.
Yeah, those are
during the
bailiffs.
course of the grand jury about the
That's what I was saying. Those are bailiffs, but aren't those guys standing behind the bailiffs I mean, those guys, I mean, I could smell them from here, man. It smells like bacon. Like straight up. I'm in Tennessee. That was 4 months ago, and I could smell the bacon in that courtroom just behind those bailiffs.
Injuries. It took a grand
and I don't know who those guys are, but they sure as shit look like cops.
juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County
Welcome,
in
Jimmy
California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty
So the Commonwealth is Massachusetts.
that these wounds are from an animal attack.
Like Virginia is a Commonwealth. New Jersey, I believe, is a Commonwealth as well.
Period. Full stop. So, what do we know about animals and the Alberts? Which is exactly where Officer John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog. There's a photograph of Brian Albert with the dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house. Where is the dog?
Yeah, Turtle Boy's not phased at all. Like, if you watch Turtle Boy, like, he's just like, yup. Every time this dude like drops a bombshell, he's like, yup. Oh man. Why are you doing this to us, Jenny?
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad. I think we got a super dad.
Jenny Junk Journal book lover, thank you so much. Good eye. Welcome from the outback. My Australian needs work.
We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two,
Chloe.
he admitted that the dog was at his home on the night John O'Keefe.
So when I go over the Turtle Boy stuff, you're going to see people with signs. I mean, you're talking crowds of people, and you're going to see people with signs that say things like, "Where's Chloe?" And if you're going to wonder what they mean by that, Chloe is the German Shepherd that they're talking about.
Early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because
I mean, people. Let's just call this what it is so far. Okay, if the prosecution has to prove beyond a reasonable doubt, meaning if the defense can present a reasonable doubt, then the prosecution can, then a jury can't convict. And we're already seeing, before the trial even starts, plenty of reasons of reasonable doubt. I mean, there's a lot of it. Think about that for a second. Like, just think about it for a second. Before they even have gone to trial, there's already enough that the defense has to create doubt. Because there's not a person in this chat with skills to be able to, with comprehension skills. There's not a person in this chat that is sitting here going, she did it, no doubt in my mind, she's cooked. There's not one person in this chat that is thinking that. I mean, let's just be honest. And we're not even done yet. We're not even done yet. So there's just too many things that is going to just create doubt. They've already created doubt. They haven't even gone to trial yet. It's insane.
if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in.
Lawyer Mystery Maven says, well, we don't know yet on the arm stuff. It's two different conflicting ideas as to what they are. Need experts to opine and jury to assess. And too early in discovery, in my opinion, to really know. Objection! Judge, can I have a ruling on that? Sustained. No, I'm just kidding. No, you're absolutely right about that. I mean, of course, you know you're right about that. But I'm just saying, like, there's other stuff that he hasn't even gone over yet. But there's the Google search from the sister-in-law, I think it was. There's the cell phone data from John O'Keefe's phone that is pretty, I mean, that raises tons of questions, and he's going to go over that in just a second.
In that house and ultimately exited that house from that party that night. Not one saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him.
Sorry, I was muted. As one person said in my chat earlier that she's familiar with the case, because she's from that area. There was a blizzard. So I mean, that's understandable that, in my opinion, that's just my opinion. It's understandable that even a 6'2" man, 200 pounds, if he was covered in snow, somebody might not have seen him. Somebody driving down the road with, I mean, and you also have to take into consideration how hard it is to see through a blizzard. If you've ever driven through a blizzard, it's the most nerve-wracking shit in the world. I mean, this is you with your wipers going 30 miles per hour tops, you know, relying on being familiar with where you are. I mean, it's hard to see, and at night. So, I mean, that part of his defense, I'm just going to be like, dude, no. I mean, come on. There is a blizzard going on. He could already be covered in snow in the yard, and, you know, just driving by, you're just focusing like right in front of you and making sure nothing's jumping out in the road in front of you and looking for tail lights, for brake lights in front of you so that you don't get an accident.
But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests had left, there's your answer as to why no one saw him. And it also answers two other questions which are looming in this case.
I mean, but are they, though, Little Miss No Name? Like, are they aware of everything? Like, even something that, dude, even a plow driver, unless he's Superman with X-ray vision, is going to have his peripherals obstructed in a blizzard. I mean, it's at least you could argue that. You know what I'm saying? Like, there's no way to sit here and be like, oh, well, the plow driver could see everything. You don't know what he could see. You know what I mean? I'm just making a point. I get that plow drivers are trained to drive through the snow and plow through snow. I get that. But if he's in the yard, I mean, he's not directly in front of him. He would be in his peripherals, and there's just no way to get, I mean, I don't know if plows go into blizzards. Just call me Hen. That's actually a good point. Because, I mean, wouldn't that be redundant? Wouldn't that be, you know, like scooping water out with a strainer? Seems like it wouldn't do much good. But I don't know. I don't know what plow drivers do. That's what I'm saying. You're focused right in front of you. You're not focused in, you know. But I mean, again, I don't know. I'm just offering a possible argument, a different perspective to what he's saying. That's all I'm doing. I don't know to what extent he can prove that. This plow driver has not taken the stand yet. So until we can hear exactly what his testimony is, you know, there's no way to actually come to any conclusion on that issue.
Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, why would he sell his house? So in the months following John O'Keefe's death, the dog has been gotten rid of, got rid of the evidence in the basement, got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury to investigate some of these circumstances. But Karen Reed should not have to wait for the
I mean, bang, bang, kiss, kiss. That's actually a fair thing to say. I mean, don't apologize for saying it. I mean, we're talking about if the defense is right, it's a valid thing to fear that a witness that could exonerate this woman could be in danger. You know, I mean, if we're talking about dirty cops, we're talking about dirty cops. You know what I mean? I'm not saying they're dirty. I'm saying if they are, it's a genuine fear. It's a legitimate fear.
feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense, the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something. And then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, that those summonses issue, the request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing. I think we've established this is not just fishing. We got a fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the.
Yeah, I don't know, Petty Patty. Again, like the title says, this is just an introduction to the case. I still have a lot of deep diving to do in this case. A lot. There's a lot to this. This is just to familiarize what the defense is trying to do here and what they're basing their defense on, what the story is, and what the defense is basically trying to do here. So that's all this live stream is about. This is not going to be a deep dive into all of the deep details and facts into this case, not this live. But I definitely plan on doing that. That is exactly my intention. I do have the affidavit. I'm going to go over that in another live stream. But this one, like I said, this is just for all of us to familiarize ourselves together a little bit on this case.
The summonses surrounding the animal control and town clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated and we've suggested that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth. There is new information. There's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the
Of course.
first.
I disagree with you, Jessica Boone. I disagree with you. If you know, doing something that is not, I don't like the idea of the dog having to go through anything, but if it's going to exonerate an innocent person, then then take samples, do what you got to do. You know what I mean? It just is what it is. I know there's animal rights people that would feel absolutely different than I would. But you know, I don't agree with putting a dog down just because a dog was being protective. That's not what I'm talking about. But I'm talking about if that dog happens to be evidence and putting it through a little discomfort for a brief period of time in order to exonerate an innocent person, um, then I feel like that's necessary. It has to be done. But we can agree to disagree on that. No harm done.
Thank you. Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that, but counsel for the defendant. As far as the injuries,
Now that caption was wrong. This is not Alan Jackson, the defense attorney. The gentleman that was just speaking is Alan Jackson, one of the defense attorneys. This is the prosecutor.
are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video.
What do you expect this lady to do, though? Dude, if it's me going to prison for the rest of my life, or a dog, sorry. I'm sorry. Think what you want to have your opinions about me, but if that's all I'm saying. If it's a choice between unaliving a dog and me going to prison for the rest of my life for something that I didn't do, the choice is pretty easy to me.
Surveillance video from the waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. The same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the record, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not.
Yeah, that's what I thought. I mean, the dog, wouldn't they just have to like swab the dog's mouth, That's it, Maybe worst case scenario, they stick a syringe in the dog and extract a little blood. Then, get the dog a treat. That's it. Take him to the park. It's all good.
Intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition. indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as the,
Allegedly, AM. Allegedly.
as I just stated, the sort of epitome of a fishing expedition. It's language such as it could shed light, or if true, this fact would undermine the prosecution's entire theory of the case. There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record, those are not the calmos theories. No one ever said that the vehicle struck Mr. O'Keefe in the head and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But those could, and if true, those very words by definition evince the very nature of this particular request. The first issue would be with the time frame, as it's stated within the motion. It's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head, that there's evidence of defensive wounds, there's a cluster of deep scratches and puncture wounds to his upper arm and forearm, and then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, where Mr. O'Keefe was taken immediately from the scene where he was, his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are, then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch marks.
Yeah, this is a feed thing. The reporter will come up and say this.
Well, we've had an interrupt in the feed there from the courthouse at
I just
the
said
Dedham
that.
Court, but we've been listening to attorneys talk about their motions in the case of Karen Reed. Let's go back.
As far as how the medical professionals detail what those injuries are. In those medical records, what the personnel at Good Samaritan, the doctors, the nurses who examined Mr. O'Keefe when he came into their facility, they described his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration. Positive for surrounding soft tissue, swelling, positive breath sounds bilaterally, pulseless, positive superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case, who testified at length before the grand jury, described Mr. O'Keefe's right arm injuries.
I agree that they don't look like bite marks. I mean, that's my issue. Is I think they look like scratch marks, but not bite marks. That's I'm having a hard time wrapping my mind around. I don't think that they look like bite marks. I can see. I feel like if I'm picturing a dog attack, you know, I picture that dog having a firm grip on John's arm. So, you know, those wounds were not consistent with that. Those wounds were that of a dog who had no jaw strength whatsoever and just, you know, their teeth just kept scratching and he couldn't get a grip on his arm, which is possible, I guess, but highly unlikely. And I mean highly unlikely. I just don't, I don't see those being, I don't see those being consistent with bite marks from a German Shepherd. So.
As scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And
let's do something real quick. Give me 1 second here. Yeah, folks. Yes. Take a looky here. None of these. I Googled German Shepherd bite marks. Okay. Like, I mean, that's pretty specific, man. That does not look like anything that we saw in that photograph. Now, scratch marks, maybe. Scratch marks, maybe. But I'm not seeing anything consistent with what we were looking at. It just looked like scratches. Right. I mean, so the whole thing with the dog, I'm just not buying. Not I'm not buying the cocktail glass on the ground bullshit either. just for the record, I'm not buying that shit either. That's not road rash. But right, exactly, lawyer, Mystery Maven. This is, it's just not consistent with anything you'd normally see, unless there's just something wrong with this dog's jaw strength. And with this dog's jaw, even without the jaw strength to be able to take a grip, we would have seen a pattern of teeth marks, not just one after the other like that. It doesn't seem likely.
Worksman Jackson and Quinn, along with Elizabeth Little from Worksman Jackson and Quinn on behalf of Karen Reed.
Good afternoon, Mr. Jackson. Good afternoon.
Yeah, not road rash either. I agree.
Okay, so,
We're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are two motions before the court that we'd like to be heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases. And I would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court.
What's up, Electra?
We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in two prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life. And for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator.
See, that's what
Her family.
I agree with you wholeheartedly, Petty Patty, on that. I just don't. It makes no sense. I'm not buying the dog attack on that. Something else happened. I'm not buying the road rash bullshit either. That's just not even. I just don't see that being a thing. But I'm not buying the dog bites either. If a cop, I'm going to assume that if a cop buys or adopts or buys or owns a German Shepherd, it's because he knows that German Shepherds are generally used in law enforcement, and he probably has the dog for protection and probably relies on this dog to be able to grab someone's arm and not let go with a firm grip. So I just don't see a German Shepherd that's owned by a cop making those kind of half-ass, marks on his arm. It just doesn't add up. Yeah, yeah, the dog thing just doesn't add up to me at all.
Family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case.
But what's really interesting as well is that the defense wants the dog found and tested. So, I mean, it would be foolish of them to be this sure about it so that it could be disproved by the prosecution. It would just help the prosecution's case if it wasn't a dog. And it seems almost naive for lawyers with this kind of training. This has got to be some other, defense strategy. So some veiled defense strategy that I'm just not getting, because if there's just no way that that's actually a dog attack, why are they so hell-bent on getting that dog found and tested to compare, to find, basically to eliminate, if it's not the dog, to eliminate that the dog bit this man? So I mean, I don't know. It seems like a weird strategy for the defense, because I don't think anybody in here is buying that's that's a dog bite, that any of those things are dog bites. That's what I'm saying. And I don't see the likelihood of a police officer owning a German Shepherd that is known for canine training. I'm not saying the dog was trained as a canine. I'm just, you know what I mean? I'm not saying that, but I'm saying I just don't see this dog not being trained properly by that law enforcement officer owner. Not necessarily trained to be a police officer, but at least trained to effectively protect the home and the home and the home's occupants. I don't see how. Claw marks possible. Now, here's another scenario. What about if the dog was trying to get to him, right? And the dog was being held back on a leash to where he would not allow the dog to actually bite. See, that's a possibility to me. So I just, They said what in a court appearance? Oh, that they have their own experts. I mean, that's what I'm saying is it could be dog scratches, and it could be the owner of the dog holding the dog back on a leash and keeping the dog from actually biting, but the dog is still trying to attack. That's a possibility. It seems a little thin, but it still seems like a possibility. Let's see. This will probably end up being a question of fact for jury, which marks are state for one theory versus defense theory. Each will have expert to support. Right. Got to argue state theory. So this is a creative argument. Okay. I mean, like I said, I'm not gonna jump to the conclusion of this woman's innocence. I still have a lot to go over, but if the dog could be disproven, I just don't see why the defense would be so hell bent on using it. It doesn't seem like a smart strategy.
She's hired private counsel from two coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11 months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it. We haven't inspected it. We haven't been able to test it. In February of 22, the police seized pieces of tail light.
Yeah, if you're just joining JW, I've already thought of that. I'm going to explore Turtle Boy. I'm going to explore Turtle Boy's content thoroughly, as much as I can. Like, I'm going to do a deep dive into all of this. This is just scratching the surface here. This is just to familiarize ourselves with the case, with the existence of the case, not the actual evidence of the case necessarily. This is just to spark some discussion and spark some interest, and we'll oh, Rio Heist. I mean, if that's why you're subscribed, I don't know what to tell you. We're not, no, there's nothing to talk about Colton anymore, unless you know something I don't. But as far as I know, Colton is living a nice, quiet life in peace out of the public eye, and I wish him all the best in those endeavors.
Light from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending.
What's up, Corvette?
8 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, the response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing.
Oh, well, we
Because
already
the application is made
walked
good
that.
by dog and then
I
gets
don't know
dragged
why it
out.
went all the way back to the beginning of that.
Pass the sniff test. These are not from a cocktail glass.
Okay, this
John
is,
O'Keefe died. Know that he was beaten. Reserve and
That makes
Support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
okay. So the second Rule 17 motion, are we
Because
going
I'm-
forward on that and then?
where I'm at right now, this is what I'll tell you with the little that I know on this case so far. But the little that I know so far, where I'm at is I'm leaning towards he was in that house. Something happened in that house. Now, what I'm not leaning for, I'm not buying the dog theory. I'm just not buying the dog theory, but I think something happened in that house. Speaking of dog, what's up, panda lady? I haven't seen you in a minute. What's up, my panda girl? She heard me defending the dog and she was just like, let me come down there. So yeah, so far I can't get on board with the dog theory, but I am leaning towards that he was in that house based on the cell phone data and based on the Google search from the occupant in the house. Oh, I can't. She's too big for me to pick up.
And having the hearing regarding the timing of the video, how are we going forward with this? Before I hear from you on the substance, Mr. Jackson, what is the next date for?
May 25th.
Right, what's it for? The evidentiary hearing?
Yes.
All right. So do you plan on arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
That
argue
makes sense
the
to
17th that day.
That makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally.
There
I'm not
is.
going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you. With regard to the dog, first of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten facially and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of it. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, we don't suggest that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a cocktail glass. Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there while she jumps in the car, slams it in reverse, then hits him with the car, with her taillight in the back of the head. It makes absolutely no sense.
Yeah, that doesn't make sense
That is the
either.
Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time, temporally at the same time, that he was otherwise.
See, he's putting too much weight into that animal attack. Like, if I'm this lawyer, I'm just leaning towards the whole, this is the prosecution's case, and it just simply doesn't make sense. But I'm not going to invest so much in the animal attack, because if you can't prove that, you're really risking the jury. You're really risking credibility with the jury. It feels like, anyway, because that's a gamble, dude. That's a gamble, because that shit does not look like a bite mark from a German Shepherd, from a big ass dog. None of that looks like a bite mark from a big ass German Shepherd owned by a cop. It just doesn't add up. So, I mean, but explaining that comes from a broken cocktail glass and he got hit in the back of the head by the tail light, like that doesn't make sense. That doesn't make sense. I mean, right, you said that he already probably has an expert willing to testify on the mark's origins from the dog, but even still, even an expert telling me that, I'm gonna go. I mean, I'd have to hear him, of course, but it's hard to picture a scenario where anybody can convince me that is any of those marks were a dog bite. You know what I mean? It's just hard to do that. But you're probably right. But it feels like, in just theory, again, like we're not even close. And that makes sense why he would be willing to push it. Thank you. But it just feels like, in theory, if all you have to do is create doubt, then just create the doubt. You know what I mean? Just create the doubt and go with the whole crazy scenario of the taillight hitting them in the back of the head. That's crazy. That doesn't make sense. And just poke holes in the prosecution's. I mean, if you got one cop saying it's road rash, and then you got another cop saying that it's a broken cocktail glass that he had in his hand, then I'm gonna be like, well, why does the prosecution? Why can't they just pick a theory here? Why does the prosecution have two theories? Because that right there puts doubt in the guilt when it comes to the guilt of this defendant. Right there, that creates doubt. Why not just be like, okay, so which is it? If I'm addressing the jury in closing statements or even opening statements, I'm going to be like, okay, well, the prosecution's saying it's a cocktail glass, marks from a cocktail glass, and they're also saying that it's road rash. So which is it? And that he got hit in the back of the head with the taillight. And then there's the evidence of the taillight. So, I mean, it just feels like it's so easy to poke holes in their entire case, which is enough for a jury to just be like, I don't know. And when a jury's like, I don't know, well, then you don't have a case. That's called doubt. This is doubt. That's doubt. that would acquit her.
Was beaten and then ultimately left for dead. Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments.
I agree with you,
I
Jessica
mentioned the
Moon.
basement because that
Jessica Moon, I absolutely agree with you. I don't think it looks like either or. It doesn't look like a cocktail glass, though. Doesn't look like, I mean, just broken glass right there, and then it's all consistent. I don't know. It's just weird, man. I can only assume that there is a weakness in the other potential defense arguments. So he thinks this is one of the best, strongest to create doubt. Defense attorney has to be zealous and take no chances. Yeah. I mean, that makes sense too. Because the defense doesn't have to be consistent. The defense just has to be able to call out the prosecution's inconsistencies and make it make sense. They just have to convince the jury of the prosecution's inconsistencies. They don't have to prove they don't have to disprove their inconsistencies. It's not on them to do that. It's on the prosecution to be consistent.
because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went to the house. They haven't. They just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone establishes.
I've mentioned it, Lindsay Kane, and welcome. I have mentioned it, but we haven't done a deep dive into that yet. I promise we are going to really, really get into this case. This is not the only live stream I'm going to do on this. For those of you just joining, as I've said before, this is merely a okay. Per request. See, Lawyer Mystery Maven gave me more validation. Says I know law. There we go. This is merely just a kind of an introduction, as it says in the title, to the case, and familiarize the vibe of how this is going between the defense and the prosecution. That's all this is. We have not done a deep dive into the evidence, but I plan to. I plan to go down a deep rabbit hole on Turtle Boy's content and discuss what he's doing, because it's fun. It's fun to watch him at work. I gotta tell you. What's up, Killshot? It's good to see you, buddy.
That once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died. If that's what their theory is, he would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to.
Yeah, I think that's more damning than the Google search evidence. I mean, because if I'm okay, so I should tell you guys a little bit more about that Google search. I'm not exactly sure who it was. I heard it was somebody's sister-in-law. I think it was the cop who owns the house, his sister-in-law, I believe it was. And supposedly on her phone, she Googled something about how long does it take a human to freeze to death. And so, hey, thank you, Mystery Maven. Man, you saved my butt up here. I really appreciate your insight. Always appreciate it. And guys, make sure to subscribe to Lawyer Mystery Maven, man. She's done amazing work with the West Boys case. Amazing work. So if you guys follow that case, make sure to check out Mystery Maven. Lawyer Mystery Maven. I need to do this. Okay. All right. I just dropped Lawyer Mystery Maven's link in the chat. Make sure to click on that and subscribe. When it comes to crime cases, I'm listening to ex-cops and lawyers. Okay? So my suggestion is you do the same. Yeah, let me get into real quick. Let me get into the Google search. What was mentioned in the chat was there was a Google search about, how long does it take a body or a human to freeze out in the cold, which seems pretty damning considering that at the time somebody was freezing to death out in the cold on their front lawn. That's extremely damning. But I could see arguing that and just being like, well, there's a blizzard. I mean, it was absolutely pure coincidence because there's a blizzard. I was talking to this dude, come up with some bullshit story. I was talking about going out and going for a walk in a blizzard, and somebody made a joke, and then we started arguing back and forth about how long it would take to freeze. And so I Googled it. Easy. So, I mean, but to me, the Apple Health data that states, I mean, because if he was merely just outside of the car, if he was in the car and then just outside of the car where he gets run over, right? But his Google Health or his Apple Health data states that at the time he took 88 steps. Yeah, I realize that, Emmy Elizabeth, but I could still argue, that it was just coincidence. That's all I'm saying. But the Google Health data to me is a little bit more solid because it says 88 steps and he climbed 3 flights of stairs. I mean, it's that specific, and it's a 3-story house. So, I mean, to me, that's way more damning. Now, the two of those things together, extremely damning. Two of those things together, but I'm just comparing the two. Like I'm more focused on that than I am the Google search, only because if I'm playing devil's advocate, I can dispute that easier than I can the Apple Health data. That's all I'm saying.
To the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious.
Okay, so I've only had brief conversations with 2 very intelligent people that I trust their opinions, okay? Only a brief conversation with 2 people about this case. And they're both convinced that she's innocent, okay? So that holds a little water with me. But again, I have to do my own research and I have to find out. I have to make my own opinion. But have no fear, just relax. I'm trying to comfort you guys who are just like, I need you to believe, Claire. Okay, like I get that. I absolutely get that. But I'm never going to jump to that conclusion without actually doing a deep dive on my own with my own. Yeah, there's just no way. I would be a fool if I just took other people's word for it. And I would hope that you guys would not I hope that you guys would not rely on my opinion on something like that based on collecting a lack of evidence on hearsay of 2 other YouTube creators. So what I have to do, and I will do, and that's all I'm saying, to comfort you guys right now. Some of you guys are just joining and you guys are like, oh my God, she's so innocent. Why don't you believe that she's innocent? I'm not saying that I don't believe it. I'm saying I have not researched this case enough, but I promise you that I'm going to. Before I form an opinion, I am going to. Okay? I promise. I just haven't gotten there yet. I am sharing the experience of exploring the surface of this case with my chat. This is something that, if you're new to the channel, I do often with new cases. So I just want you guys to know that. That's all. I haven't made an opinion only because I have not looked at enough information to form an opinion responsibly. That's all I'm saying.
With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever.
Oh no, not again. Not again.
think we got a super chat. Super fan. I think we got a super chat. Super fan. Super chat. Super fan. 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 I think we got a super chat. I think we got a super chat.
Hell yeah. Thank you, Lindsay G. I think we got a super chat. Oh my God.
He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, if there's no sign of an altercation or fight, how can you turn around and say that a cocktail glass did this? They can't talk out of both sides of their mouth. How could they reasonably ignore two black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague.
See, that's interesting too. That's an interesting point too. I mean, how is just being backed over one time, how is that going to cause those kind of injuries to someone's face? And then on his arm like that, it just doesn't make sense.
I think we got a super chat. Super fan. I think we got a super chat. Super fan. Super chat. Super fan. 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 I think we got a super chat. I think we got a super chat.
Thank you, Corvette Sally. I appreciate it. Yeah, to me, I think that's a solid defense. And I think that that's the safest way to go. As I was kind of, alluding to earlier, he's kind of doing what I was saying, I would be doing if I was the defense, calling out the prosecution on speaking on both sides of their mouth. I'm going to be like, if he didn't get into a fight, and this is supposed to be a cocktail glass, you know what I mean? Like, it just doesn't make sense, especially when he's got two black eyes, laceration on both sides of his face, lacerations on both sides of his face. That wouldn't make sense if he was merely hit by the car, because he would have an impact on one side of his face. And if he was or dragged, whatever, then there would be a road rash on his face, right? Unless he lifted up his head. But why would he lift up his head and then turn his head around so he could have it? It doesn't add up. So, I mean, I'm definitely not buying the prosecution's case on her hitting him with the car. I'm not buying that shit either. But I'm not buying that those are dog bites either. So, to me, that's weird.
Colleague has once analogized. Of course, there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical exam.
Yeah, if both hands are, it just seems so unlikely. If both his hands are deeply bruised, the back of his hands, then somebody was beating the shit out of him. Now, I'm not saying that he got beat. He got beaten with like a baseball bat, because then he'd probably have some sort of skull fracture, to say the least. Zip ties, no. Bruises on the back of his hands, not his wrists, but back of his hands, would indicate that he had his hands up like this while he was getting hit. But I don't see really like fists unless he was getting beat up by multiple people. I see that as a possibility. But I'm just not buying the dog bites. That's all I'm saying. But it definitely feels like he was in that house when the prosecution is saying he never went in. That's shady. And then there's the Google search, and then there's the data that totally just defies the prosecution's case, saying that he never went into the house, because that Apple data absolutely, Apple Health data absolutely indicates that he did. And specifically, I mean, 3 flights of stairs and he's in a 3-story house. I mean, let's get real. Now, I'm wondering, does it say that that's where his location was?
Examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight, not just a fight, a brutal fight.
A beating.
And what does a dog do when its owner is in a fight? What does a German Shepherd do when its owner is in a fight? Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, or what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course, I don't know everything that's in the records.
The only thing that makes sense to me as to why he's sticking to the dog attack thing is what lawyer Mystery Maven said in the chat. She was saying, well, he's probably got an expert witness lined up. And if he's got an expert witness lined up, then he's sticking to that, and he's going to sell that as much as he possibly can. So, and if what's going to happen is the prosecution's going to have an expert witness that they bring up, and the defense is going to have their expert witness that they bring up. And whoever's more convincing to the jury that those are wounds inflicted by an animal or a dog, well, that's that's who's going to win the jury over on that. But I just don't think that there's a lot. It just to me, I don't know, man. That dog don't hunt. Oh, come on.
And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. Say the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist, because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all 4 standards of Lampron, and the summonses should issue. And also,
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to
No. JT May, listen, I highlighted your comments so everybody could see your typo. That's the only thing we're focused on. We're not focused on the point of your comment. So don't try to save it. Everybody, K-Team A can't type. That's the focus of this comment, people. I'm just kidding. No, we got you. We speak typo here. We totally know what you meant. Thank you for that. That's why I highlighted it, actually, because it's important to know what he died of. Thank you.
Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to cocktail blast would be somewhat ridiculous. That's not what I said. And that's not what I was attributing them to. And I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle. They arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data for Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the counsel is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit the defendant has not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to the defendant's phone.
Okay, I'll hear you.
So there were 2 motions to impound that the Commonwealth had filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, and really to
Okay,
both motions.
and those are impounded by statute.
Right. The other motion to impound that I filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this.
See, I'm wondering if the prosecution has proof that they were fighting. I'm wondering, because we've seen this 100 times, where we just don't know what the prosecution has until trial. So I'm curious and don't bite my head off here. Don't bite my head off, you guys, like a German Shepherd would. Oh my gosh. I know. But I'm wondering if they have text message, because we've seen this in trials before where we have no idea what's on the text messaging data or anything. We have no idea. So for all we know, the prosecution just has a shit ton of damning evidence from cell phone data. I mean, we've seen it 100 times.
So on behalf of the O'Keefe family.
I'm not sure they hear you.
Okay. In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records.
The judge was like, because these lawyers are talking amongst each other, you know, they got a Karen Reed sandwich going on here, and she's like, she realizes that they're not paying attention. She's like, I'm not sure they can hear you, which was like the nice way of going, hey, you guys over there, shut the fuck up, listen up, because I don't want any fucking bullshit later on about you didn't hear his rebuttal to your motions that you filed.
To Mr. Albert and Ms. McKay. I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal, and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion specifically.
Oh man, I wish Mystery Maven had not left, because that's a question I would have for her. Is do those documents unredacted become public once they submit them to the defense? So is that the reason that he's stating that those pieces of evidence that they're filing motions to be able to obtain, is that the reason why he's that he filed a motion to impound them? So I'm curious about that. Does it automatically become public once they submit it to the defense to review?
On page 11, there is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Unetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is, the cat's out of the bag now.
Right, yes. So, I mean, we're
Look at y'all, man. If I was Gray Hughes, I'd be getting mad at y'all, man. You're here talking about animals and shit, talking about pets. Fuck you think this is? Over here. Listen, yeah, I'm over here trying to go over a trial here. It's just trying to go over a court hearing, and it's just a little weird. You guys are talking about your dogs, and you know, it just feels a little weird. You know, I don't know. It's, you know, I mean, I'm trying to go over a court hearing. You know, this is important to the case, and you guys are talking about your dogs. It's just a little weird, you know.
We're agnostic on this motion to impound. You know, we have access to it. The Commonwealth has access.
I
to
love
it.
Gray.
The
Just
court
nothing
has
around. I
access
love
to it.
Gray.
All right, so by statute, everything that was raised by the Commonwealth was supposed to have been requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just
Right.
filed on behalf of his motion.
Right, and we don't have.
When he was taking issue with the defendant had filed.
Right. Okay. Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed by statute. So is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Yannetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still have received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that counsel had asked for a raw extraction copy of the material from the defendant's phone, which was then provided to counsel on March 22nd. So for over a month, the defendant has had access to the defendant's phone and the Commonwealth has not, because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion's allowed by agreement?
That's fine.
Okay.
Thank you.
Clerk? Motion's allowed by agreement.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive testing that I thought.
He argued that a while ago.
Okay, and was that acted upon by the court?
He said he was waiting to hear back from you where we stood on that.
Right, so with regard to that, Judge, we're all for exhaustive testing as long as we can have our expert present at the time.
So, Mr. Lally, would you say again what you explained to me?
Certainly, Your Honor. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case, that where exhaustive testing is necessary and the sample will be subsumed within the analysis. So I provided that to counsel. I just simply need counsel to execute that form, indicate whether or not they want someone present and who that person is, what their contact information is, and then provide it to the lab. The lab will then contact their expert and schedule a time for the testing to be done.
Okay, we're happy to do that, but my understanding from Mr. Lally's earlier argument is that only applies to the hair that was found on the car. That was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
Is there exhaustive testing on any of those items, Mr.
Not that
Lally?
I'm aware of.
Okay, fine. Yeah, so we'll sign regarding the here. We're not concerned about that.
Okay, is that everything?
From the Commonwealth, yes.
I believe so, Judge. Thank you.
All right, thank you. We'll see you on the 25th.
Okay, so that's that. All right. Now, just to give you guys a little idea in regards to what goes on outside the courtroom. Fun stuff. um Now, this is a dude named Turtle Boy. We're only going to go over a couple of his little short videos before I wrap this up, but now I still have some digging to do, guys. Don't get me wrong, okay? I still have some digging to do. So I don't know who this Carl Dougal or Dougal I really don't know who he is. Before I get into that, let's watch this because this looks fun. Party at D&E.
So we are outside.
I don't know what D&E Pizza has anything to do with this case yet. Like I said, I have a lot to go over. I have a lot to deep dive in myself. But we're gonna watch a little bit of Turtle Boy so you guys get an idea of this dude who so far I think is great. He's hilarious to me. Reminds me a little bit of JLR, except considering what is going on in this case. I mean, I'm going to get into that, Lindsay Kane. But I don't do that before I get all the facts of the case myself. I'm not going to take a YouTuber's word for as far as the assessment of the case, even if it's somebody who's done great research on it and has put in a lot of work. I realize this Turtle Boy guy is a very busy guy, but he is right there on the front lines. No, I mean, that's what I mean by comparing him to JLR. I don't think he's unethical the way that JLR is. I'm not getting that, but I'm saying he's kind of the guy. He's what JLR thinks of himself as, is, if that's a better way to put it. That's where I'd go as far as my impression of him so far. But no, you're not giving me all the facts tonight. JW, you asked me about certain things that I already knew about, but I'm taking my time in going over these things. This is not a coverage of this case. This is just to help familiarize people who are not familiar with the case a little bit, a on the surface understanding. That is all this is for. We're going to get into the deep dive stuff, just not on this live stream tonight. As it says in the title, an introduction. Okay. But yeah, we're gonna this guy makes me laugh. I like him.
D&E Pizza, owned by Chris.
Again, I don't know who how this pizza place, I guess it's owned by somebody that he does not like in this case. But he's over there, like, right there getting whatever he needs for content here.
So we are outside D&E Pizza, owned by Chris Albert, Chicken Parm Charlie. We're here to do a little protesting. We are demanding the resignation of Chris Albert from the Board of Selectmen. We got our signs and everything here. Down with Chris Albert.
Okay, so so the last name Albert indicates to me that he is directly related to the owner of the home, who he believes is responsible for, or at least knows something vital to the death of John O'Keefe. So the homeowner's brother, thank you, Lindsay Kane. That's what I thought. So they're protesting. So he's in front of the police officer's brother's pizza shop that owns the house. So his brother's pizza shop, and they're doing it to protest and call out his resignation of being on the board of what?
from the Board of Selectmen. We got our signs and everything here.
Okay, so Chris Albert is on the Board of Selectmen, which I don't know exactly what they do, but it sure as shit sounds pretty biased. Sure as shit sounds like it could be very unethical if this guy has something to do with his brother not being properly investigated.
Here, down with Chris Albert. Resign, Chris Albert. Resign from the Board of Selectmen. Disgraceful. Loser. Loser. So we're going to raise awareness here. It might even be the first day of school. I see school buses going by. A lot of traffic here. Okay. Again, I don't want to go inside because he doesn't like when I do that.
Now,
So we're just
I want you guys to understand something. This is not just some jackass who is standing in front of the Wells home protesting. Like, he could absolutely organize and get a shit ton of people out there, because I've seen him. He organizes. He's behind the protests that happen outside of the courtroom, demanding the freedom of Karen Reed. So, right, Brian Albert. Okay, that's what I was asking JW, is if he was related to John Albert, the police officer that owned the house. So this makes perfect sense. And if he's on the council, then he's got power in that city. This is yeah, I could see why that would seem very, very shady.
we're just here to peacefully protest. Is Chris here?
Fuck you, pussy.
What,
Fuck you.
What do you mean, fuck me?
Fuck you.
Why are you
Fuck
so?
you, turtle boy. You're a bully. You guys are bullies with cameras.
How are we
Bully
bullies?
with
Like, hey, my man, like, you know that people could still tell who the fuck you are, right?
a fucking camera. You're a liar.
Who are you? He's so angry. Why?
Mother every night.
Whoa, that's,
Whoa, yeah. Fuck you.
that's so rude.
Paused it right when they showed his face. I haven't seen this one yet.
That's so rude.
Wow.
What? Oh, I didn't ask for it. It's okay. I know, but we're just here. I know. We're just. Is Chris here? Where's Chris? What? Where is he?
I don't know. He's off today.
Tell him to come down here. I want to talk to him. So anyway, we're here peacefully protesting for justice for John O'Keefe. I didn't announce this because this is going to be a one-man protest. We are here with Richie here. He is documenting this, but we are here to peacefully protest. Last night at the Board of Selectmen meeting, we had a really good turnout of Canton people who are demanding better for their town. So if you're in the area, feel free to come down. We are peacefully protesting again outside of D&E Pizza. Colin was in the house. Uh-oh. He came out with the screwdriver. Colin was in the house. He was inside the house. Inside the house.
Wow. Okay. Now, I don't know who this guy is, but like, he loves to like just get in the face. Like, this guy's got balls, dude. I gotta give him that, man, because if like he's getting in the face of who he believes are corrupt police officers. Corrupt police officers they're capable of some shit, you know, and I would imagine in Boston, capable of some shit. This guy's got fucking balls of steel, dude. So like, this is him getting in the face of a guy who on the thumbnail it says corrupt cop. So let's take a look at this.
Sergeant Bukaki, are you trying to arrest me for wiretapping? Why were you talking about me during your whole interview with Lucky Laughlin? What have you done to follow up on the Fort Edge? What have you done? What have you done to follow up on that Ford Edge that Lucky Loughlin told you about? Why did you not interview? Why did you not interview? Why did you not interview? Why did you not interview Lucky Loughlin?
Wow.
Why did you not interview?
Why are you such a
Lucky Loughlin,
douchebag?
sir, until August 10th. After, are you ashamed? I mean, is this why you went to the academy to cover for punks like Michael Proctor? You're Michael Proctor's bitch. That's all you are, son. You're Michael Proctor's little bitch.
Wow, dude, this guy is fucking unreal, bro.
And these two guys here, they know it. They're looking at you right now like this guy's a fucking joke. I can't believe I have to wear the same uniform as this clown, as this corrupt pig. Look at you. Look at you. You freaking pig. You
Oh my
disgust me.
God,
You
dude.
disgust me. You loser. You
Yo.
loser. You freaking loser.
You loser. Wow. Yeah, we're just going over. I'm going to do one more here because this one was pretty funny. Now, this guy he calls him local moron Carl Dougal. And I don't know if he called somebody else a moron on Court TV and then Homeboy got mad at him during his interview on Court TV. I'm not going to show it because I don't want to get dinged by Court TV. But he calls this guy a moron, Carl Dougal, which is pretty funny. It's in his title. Like, loser.
I see him.
Oh boy.
Shameful.
It's gonna be good.
There's Carl Dougal. He's a disgrace. He's a disgrace to the Boston Police Department. He's a disgrace. He needs a personal escort. Look at him. Look at him. Look at that coward. He had a lot to say to Karen Reed. He had a lot to say to her on May 24th. Not so much to say now, huh, Carl? Not so much to say now, do you?
Wow, dude.
There's Carl Dougal. He is a disgrace to the Boston Police Department. Carl is well aware that Karen Reed did not kill it, but Carl's feelings got hurt. Carl's feelings got hurt because Karen didn't call him back while he was experiencing trauma. Is that true, Carl? Are your feelings still hurt? Carl, can I ask you something? Why did you keep your car at Karen Reed's house for 6 months after John was killed? Why did you do that? So you were using...
That's interesting. So according to what he's saying now, I don't know how much facts are behind this, people. Again, you know that I don't subscribe to this stuff unless I have data and proof. But what he's saying here is that this officer, Carl Dougal, kept his car stored at Karen Reed's house for 6 months after John O'Keefe's death. Which, why? What in the fuck is the reason behind that? That I gotta know.
Using her, right? She was useful to you, wasn't she? She was useful to you. After she was charged with murder that you know she didn't commit, you allowed your car to sit in storage at their house for the next 6 months. Why did you do that, Carl? Why didn't you go and get your car? Carl, is it true that you got John's car painted after Karen Reed backed into it? Is that true, Carl? Are you part of the cover-up, Carl? We apologize for this scumbag coming by. This guy's a horrible person. He's horrible. He's horrible. His wife is just as bad.
Wow.
Jackie Dougal. She calls herself Hit Mom. She had a lot to say to Karen Reed. She's a mean girl. She's a bully. She's a bully. She's a bad person. She's a disgrace. And Carl is a glutton for punishment. Look at him. Carl, why don't you wear your assless chaps today?
I bet you're gonna park closer next time, Carl.
Any comment on those, Carl? On the assless chaps? No?
Assless chaps. What's the story with the assless chaps?
What a scum! What a loser! What a loser!
What's the story with the assless chaps, bro?
Loser! What a loser! Disgraceful, Carl! You're a goddamn disgrace to the Boston Police Department. You bring shame to John O'Keefe. John O'Keefe is looking down from heaven at you and shaking his head. He is shaking his head. John deserved a better friend than you. Here's his old man car. Here's the old man car. There he goes. Oh, Carl. Disgrace. You're a disgrace. Disgraceful. Disgraceful. He's a disgrace. Look at him. He's a disgrace.
I mean, look at all those
Bring
people.
shame to the Boston.
Like, he organized all this shit. Like he organized all this shit. Like, these are all people that he got out here to support Karen Reed.
Police Department. What a loser! What a loser! Loser!
What a loser!
What a loser! A lot to say. Not so much to say now. Why do you do this to yourself, Carl? Why do you do this to yourself? Are you a glutton for punishment, Carl? It's gonna be like this. And, oh, she's taping us. She's taping us. I love when she does that. Boo! Loser! What a loser! That's called. John deserved better friends than that. What a poor John. Poor John. He must be looking down from heaven and just shaking his head. Just shaking his head
Oh
in
my god,
embarrassment
dude.
for Carl, who's sitting there with the people who murdered him. What an absolute disgrace. John deserved better friends than that. He deserved better supporters than that.
I don't
It's
have that
really,
in me,
really
bro.
sad. It's sad. So he had one person in his life who actually gave a shit about him. Her name was Karen Reed, and we're never going to stop fighting for her.
I just don't have that in me, bro. Like, to just like scream through a fucking bullhorn and yell at people. I'm not saying there's anything wrong with what he's doing. If she's innocent and he's creating all this awareness of her innocence and taking on an entity like the Boston Police Department and the Massachusetts Staties, dude, like, that's badass, you know? But dude, he's a loser. Tell us about the assless chaps. Oh my god, that shit is too much fun, bro. Yeah, he's definitely got cajones. He's definitely got cajones under that malangouche. Telling you. Oh man. But yeah, guys. So like I was saying, this was just an introduction. I hope everybody kind of gets the gist of what the situation there is in Boston over this case. It's crazy. Like, when Dietz and Chasing were telling me about it yesterday, I was like, wait a minute, what? And then because she was saying the names, and then I had heard about this case and I watched one little short thing about it. And then I was like, oh, the cops, the cop who got killed by his girlfriend or whatever, right? And then they were like, yeah, but so I was like, okay, and then they started telling me, this stuff, and I was just like, whoa, okay. So I'm definitely invested. So once I started watching a little bit of Turtle Boy, but after I watched that hearing that we just went over, once I did those two things, then I was just like, okay, I'm going to start talking about this, most definitely. And because, I mean, it's fascinating to say the least. I have to go over more shit, which I will do live. I will do like I always do everything else. And eventually I will form an opinion, probably, most likely. but in the meantime, you guys know how I roll here, man. I don't just go by people's word. So what I do is I like to look at all the facts myself. I have the affidavit. I'm sure there's more stuff to look over, and I'm gonna look at that stuff. I am maybe the next time I go live, I'll read the affidavit, and I'll wait till I go live to do it, so that something that jumps out at me, you'll get a natural reaction from me. So I'll wait to do that, but and then we'll do the other tragedy pimp stuff still. I'm not shying away from that in any way, shape, or form. What I'm not going to do is engage in what took place yesterday, because I was and I don't regret it at all. What I'm saying is I was angry and I felt the need to speak up, and I was very clear, I believe, in how I felt about it, and I still absolutely feel that way. But do I plan on pursuing it any further? No. I mean, if Deet's made her decision and she's left YouTube, then she's made her decision and left YouTube. There's no sense in beating a dead horse. It just sucks that the person who would probably bring you the best possible content, the most insightful content on this platform regarding this case, won't be doing it. And so unfortunately, you're just going to have to settle for me or the next person who just does it better. Apparently there's stuff going on behind the scenes with people that I had wrenched, whatever. There are people who got the wrenches back. There are people who don't. I am cutting myself off. At least as long as they behave in chat, they're cool. But as far as their connection to myself and this channel on a creative level, as far as my association with them as mods and me as a creator, if you were involved with some bullshit that was taking place behind the scenes and you were involved with people who basically had a major hand in this bullshit that took place yesterday, and it happens behind the scenes that I'm not aware of because I don't do anything or hang out behind the scenes. I don't communicate with people behind the scenes for the most part. I don't know what's going on. I don't care what's going on. I don't care what people are saying about me at all. But I can't expect the mods that I do trust the most with my channel, I can't expect them to function here in my chat to the best of their ability if there is attacks against that person behind the scenes, and it's not fair to them, considering what they've done for my channel. So that's why I took certain wrenches. I'm not eliminating anyone from the chat or hiding them. I don't care who you talk to. It's fine. I can't trust you with a wrench is all it is. It's just that simple. I can't, the flip flopping and the shit talking and the fucking, the chicken is fucking, clucking back and forth at each other and then being best friends. And then I don't play that shit here, man. I don't have the patience for it. It's childish. And I just want nothing to do with that type of bullshit. Not in connection to my channel. Now, if you're You're welcome in my chat as long as it doesn't happen in my chat, but can't trust you with a wrench if you engaged in that stuff or encouraged or spun, stirred shit up. I can't have it. So that's that. Anyways, guys, I love you guys very much. I am going to wrap this up. You guys are fantastic. I appreciate all the support. Appreciate everybody who joined, knowing that there wasn't going to be any drama bullshit or me raising my voice and ranting. Guys were here just to be here, and I appreciate that. It means a lot. I love you, and we will do this again very soon, my friends.